Welcome to the program. My name is Marty Shenkman, and I'm joined by, I hope I can say a friend, a colleague. Uh, um, why don't you introduce yourself, and then we're going to talk about the organization, Rabbi Brody, and um, we're going to give a lot of good practical information for listeners.
Okay, great. It's always great to be with you, Marty. So I'm Shlomo Brody. I am a rabbi. I'm also have a PhD in law, so that's
Oh,
why
I
I
didn't
always
know
love.
that.
Oh yeah, oh
Oh, I
yeah,
got to be careful now.
absolutely, absolutely. And that's why it's always great to speak with you, Marty, about these types of topics and the intersection of Jewish law and general law and American law and how they sort of interact in really fascinating ways.
So let me start with a very broad context, and this will take a minute or two. I've been doing programs and writing articles on religion and estate planning since the early 1980s. It bothered me early in my career when I would have clients of any faith, lots of different faiths, come to me, and we as estate planners would talk to these people without any thought, without any reference to their beliefs. And the surveys, at least the last time I looked, something like 96% of Americans believe in God or a higher being. How can we talk about end of life decision making and not address religious beliefs? And in the ensuing years, I've done extensive writing and lecturing on faith-based estate planning. I actually have a book in process now with a Christian colleague on Christian values and morals. I've written extensively on uh, Islamic estate planning, and I've presented lectures with Yasser Ali, who's an imam from Arizona, on some interesting techniques to address the American legal implications to Sharia estate planning. I just did last year a fascinating article uh, on the Baha'i faith and its implications to estate planning. I just finished a series on Latter-day Saints and estate planning, which was very interesting. All these materials are on the Shenkman Education website. Um, Christian faith planning, Greek Orthodox estate planning. I talked about creating a trust for a priest under a Carmelite vow of poverty, and the list goes on. So this is really part of the same vein. I truly, truly wish that everybody in this planet would make the effort to understand people of different cultures and different faiths, because that's how we can solve so much of the ignorance and hatred that proliferates. Um, so related to that, in the past less than year, I did an extensive program, webinar, as well as article on Hispanic estate planning with a colleague, and I have a really extensive long article coming out on African American estate planning in Estate Planning magazine shortly. It'll be out perhaps by the time this you see this. And Those articles were also done to expand beyond religion and extensive writings on different health issues. So, for purposes of this discussion with Rabbi Brody, who I now know has a PhD in law, which I didn't know, so I have to be careful. This month, May, is National Jewish Heritage Month. So we've sent out email blasts and articles and materials on lots of different cultural heritage months. This is part of a broader um, I don't know what policy program in America to really recognize, respect, and educate people about all the different cultures that are in our country. There's a Black History Month, there's a Hispanic Heritage Month, there's a Jewish Heritage Month. And again, just like I made the comment earlier about people trying to learn and understand and be sensitive to other faiths, we need to do that for culture as well. Think of I think of Stephen Covey, who said in his book Seven Habits of Highly Effective People, seek first to understand, then to be understood. We need to make the effort to understand the other, and then we can ask them to understand us. So that's the broader context of all this. Now, in terms of National Jewish Heritage Month, I had no idea, but Jews have been prominent in America since 1654. That's a long time, very early in the country's founding. and have had a valuable role in contributing to American society from the very beginning through today. And I want to make a quick comment on that. In 1980, Congress initiated National Jewish Heritage Week, and then in 2006, in celebration of the 350 years, and I think that was the first synagogue in the country, President George W. Bush proclaimed the first National Jewish Heritage Month. So we're going to play this program and wanted to acknowledge National Jewish Heritage Month. Just a quick comment, and then we're going to get into estate planning, is the contributions of the Jewish community to America have been vast and touched on every aspect of science, medicine, history, law, society. But I think the most significant contribution is one that, regardless of faith, needs more attention, and that is the foundation of American democracy and life based on Judeo-Christian values, based on biblical values. And it really doesn't matter what faith one is or no faith, recognizing the values, the morals that are taught biblically, I think can go a long way to addressing some of the struggles we have currently as a society. Okay, enough of my chatting. So in the context of Jewish estate planning, most lawyers are certainly not Jewish. Most lawyers that are Jewish may not have any understanding of what Jewish law is. So we have, which I don't often have the ability to do, we have a really no cost, easy answer. So Ematai is an organization devoted to empowering both clients, consumers, and practitioners to get the information and forms they need at no cost, very quickly, very understandably, um, to complete estate planning that complies with Jewish law. Now, within Jewish law, and since I'm talking with a rabbi, please correct me if I say anything wrong, there's a tremendous variation, as there is in every faith, or continuum on degrees of observance. So there will be clients that identify as Jewish that are absolutely not interested in anything that pertains to Jewish law. And there will be clients that want to comply to the full degree with whatever Jewish law specifies, and lots of people in between, as with every faith. But the materials that Ematai provides give you the ability to go as soon as the client has any desire on this end of the continuum, all the way to this continuum, end of the continuum, with what Jewish law provides for. And let me just set the bigger picture, because we're only going to talk about one aspect of, or we're going to focus this program on one aspect of applying Jewish law to estate planning, and that is inheritance rights. And just by comparison, by contrast, Islamic law has very detailed requirements under Sharia law for how and who inherits, and the mandated percentages and how they change. Um, most, well, I would say every faith I can recall studying and writing on mandates, or if not mandates, encourages contributions to charity. So that can be part of the estate plan. Most faiths have some implications to how you handle end-of-life decision making. So we're going to talk very quickly about the bigger picture, and then we're going to hone in on Jewish inheritance law and what it means. And many practitioners may find that most clients aren't even aware of this. So this could be, certainly a conversation piece. And if the client's interested, Rabbi Brody is going to explain what you can do and how you can do it. Before let me so one area of addressing planning is charitable planning, and there's nothing per se unique. There's no mandate that I'm aware of a percentage or portion of one's estate like there is in the Baha'i faith that has to go to charity. But certainly anyone of faith, Jewish or otherwise, you should talk about charitable planning because it's a fundamental value. Second, end of life decision making. Jewish law, and Rabbi Brody has done an extensive webinar with me on this topic, and it's on the website. Jewish law has very detailed implications, and there's lots of different interpretations and even some controversy, which is common among every faith, about end-of-life medical decision making. And just as a general statement, and again, I think this applies to many faiths, part of the struggle with these concepts is ancient laws are trying to be interpreted and applied in an environment where modern science has advanced so quickly. So there's a whole program on that. We talk about that. And you definitely, if you have a Jewish client or if you're Jewish and these issues are important to you, you don't want to sign a standard healthcare proxy or living will document. You want to sign a document that at minimum just mandates that Jewish law be applied and doesn't contradict Jewish law. Many of the standard forms that are available online, many of the standard forms that I've seen many law firms use contradict not just Jewish law, but lots of different faith-based laws because that wasn't on the radar when whoever created the form did it. Now, for this one topic to wrap up talking about healthcare and end-of-life decision making, tell everybody, Rabbi Brody, explain what Ematai is, because everyone, this is an incredible resource that can quickly help you accommodate these wishes. And let's not talk about inheritance yet. Let's just talk about end-of-life decision. Why don't you explain what Ematai is, what the organization does, give everyone and repeat it a couple times, the website, and tell them what resources are there to address healthcare decision making, and then we'll get into our main topic of um, inheritance law.
Yeah, thank you so much, Marty. Ematai.org, ematai.org, is where we house a lot of resources that help Jews in general just navigate questions relating to aging end of life care. And one of our primary projects is to provide something which is a document that people can utilize to express, not only declare their power of attorney or the proxy, but also to express to the healthcare providers that they care about Jewish law and custom when it comes to these decisions. And you're absolutely right, Marty, that people will sign boilerplate documents because that's what they're offered and doesn't really reflect who they are and their values. And that becomes very important to people, certainly in the moments of truth. When doctors look at these documents, it's very important. And it causes also a lot of issues when people go to estate planners or attorneys and they're trying to map this out and make the attorney understand what they want exactly. And there's a cultural divide. And so we sort of said, let's make really easy, user-friendly documents, which everyone can understand, that's legally simple to understand as well. And that way you can provide to your clients a real service and saying, listen, I'm catering towards your needs. I cannot tell you how many times I hear from potential clients telling me they're nervous about going to an estate a certain attorney because they're not sure they're going to understand what they need. And also from attorneys who say to me, I'm a little bit confused. What exactly do I need to do different for this Jewish family? And so we said, okay, let's just make it really simple and easy for you to see this document and free, downloadable, and something that you can really utilize along with, some basic explanations of some general values in Jewish law regarding to end of life care. So that way people can be much more informed when these moments of truth take place.
So this is a quick, easy, and no cost way for practitioners to be culturally sensitive to Jewish clients wherever they are on the religious spectrum. Um, let me give an example, and there have been way too many heartbreaking stories like this. I've been called not just by Jewish organizations, but by other faith-based organizations over the decades of practice, where somebody went out and signed some form, standard, boilerplate, whatever, healthcare proxy or living will, completely violating whatever their religious beliefs are. And I would get calls from religious organizations saying the kids are fighting. I had one where I was called late on a Friday afternoon by a very right-wing, very devout religious Jewish organization. It got to the point where one of the kids had thrown himself physically over his mother in the hospital to prevent the withdrawal or what they were doing. It was physical. And what do we do? And in a lot of these cases, what I had done to help these different organizations was I would review the legal documents and try to find a way to conform it to what the patient's real beliefs were. But nobody should put a family in that position. Everybody, I'm sure, on this call remembers the tragedy of the Terry Schiavo case. Nobody knew what her faith was. It's tragic that a young woman should have to face those decisions. And she was in a persistent vegetative state. And the issues were, and I don't remember which side was which, but her husband felt that one way about withdrawing life support when she was in a persistent vegetative state, and her parents felt differently. The trauma that was added by no one knowing what she believed or wanted was exponentially more horrific than what was already an unimaginable trauma of a young woman in such experiencing such a horrific death and shortening of her life. So this is really vital to do for all clients. Um, when you go on to Ematai and you get their medical or end of life forms, there's really several approaches you can use. You can, if you're comfortable as a practitioner, just use their documents exactly as they are. You may want to review it, but I know because I was actively involved, and that's actually how Rabbi Brody and I first met. He asked me if I would look at the documents, and I think if I remember correctly, you said my comments were longer than all the comments from all the other lawyers combined in all the other states. So I spent a lot of time because this stuff is important to me for every faith. I think it's important. It's fascinating. It's insightful into the meaning of life and deeper thoughts that we should all want to ponder. But you can just use their document. You can offer it to their client. Let's say you have certain things you feel are in your legal documents that are not in the form, because keep in mind what Rabbi Brody said. He wanted to make this user friendly for a consumer, compliant with Jewish law, and simple so it can't be done wrong. So you could add a paragraph or two if there's a provision you feel very important about and the client wants to their document. Or alternatively, you can use their language that addresses the religious decision making and integrate that into your document. So there's lots of different ways you can apply it depending how much time and effort you want to spend on doing this. So that's a really critical part of estate planning for Jewish clients. You will find no, a tremendous variation in different beliefs and thoughts. Um, so you have to ask the clients. You can use their form or you can adapt it. Now, a second area of Jewish law. So we mentioned charity, which is common to every faith I can think of, and everyone on this call knows how to make charitable bequests and gifts and everything else. Um, the second is healthcare decision making, which we talked briefly about, just so you have a complete picture. And the third and the focus of this discussion is, I'll say, biblical mandates or Jewish law mandates for how inheritance should be handled. And this is common amongst other faiths. I mean, the one I thought of earlier was Sharia law and how the Quran provides for mandated distributions. Rabbi Brody, why don't you explain biblically what the mandate is, and then the issue of how to make that conform with current law, and we can talk about, or I'll let you talk. I'll just comment about the other aspects of this.
Yeah, absolutely. So, within Jewish law, within one's lifetime, you can utilize your money and distribute it sort of as you wish, to children, to relatives, to charity, whatever it might be. But in the Bible, there is a default law of inheritance, which means that when a person dies, the estate is supposed to go to a specific order of inheritors. And that usually are males in the family, male descendants, sons. The firstborn might be entitled also to a double portion. It could end up being landing with a brother or a father, but it's really a default to the point where it's understood that at the moment of death, the money automatically transfers from the deceased to the person who is default supposed to receive that money. Now, for many, many generations, so we're talking about thousands of years actually already now, there have been various mechanisms that have been developed to allow people to still get their money into other people's hands, meaning other relatives or loved ones, whoever it might be. For I think what's the obvious reason is that many people want to see their estate being distributed differently than necessarily what the Bible speaks about. And that wasn't necessarily seen as a problem, but you've got to set up the proper legal mechanism to do that. The most obvious example is if a person has two boys and two girls and your daughters. So you want the money to be distributed equally, or you want at least some amount certainly to go into those daughters. And there are various provisions over the centuries, but and how to do that. But it's important to recognize that under Jewish law, if something's not done beforehand, before a person dies, it's very hard to correct that afterwards, because the money automatically under Jewish law goes to the hands, at least in title, right, to the default inheritors. And so you're really running into a situation where many people, their wishes are to have money distributed, let's say, equally amongst children, independent of gender, or to various other loved ones. But if they don't take the measures during their lifetime to set up the estate properly, that can create some issues in Jewish law.
Let me just phrase it slightly differently in case it'll help viewers. So, in other words, biblical mandates, Jewish law, halacha is the term, mandates a certain set form of inheritance. And again, that's not uncommon amongst other faiths either. But in a modern society, is exactly as Rabbi Brody said, a typical estate plan is if I have two daughters and two sons, I want everyone getting an equal fourth. And that was, in fact, my father's estate plan because he had two daughters and two sons. So you want to comply with the client's wishes, but the client would like to do so without violating Jewish law, especially if they have any religious feelings. They are going to be concerned, I don't want to violate Jewish law, but how do I accomplish this? Now, not everything under Jewish law is there a workaround for, but in this context, for hundreds of years, if not thousands of years, the sages have recognized that the biblical mandate in an agrarian society thousands of years ago may have worked there. It doesn't work now. How can you both respect Jewish law and comply with what the client wants? And there's mechanisms that can be used that are really very simple, not very involved. Is it fair to say you can go to Ematai's website and find a star, and we'll talk and explain about that? So there's a simple step you can take that'll take very little time so the client technically complies with Jewish law, but accomplishes their inheritance objectives. So again, if the client, depending where they are on that continuum, if they're a little more towards the religious and not towards no interest, this may be important to them. They may not even be aware of this. And you, as the practitioner, now that you've heard this, say, listen, I can go to this website and get you a document. You can sign it. It'll take an extra 15 minutes or 5 minutes. And now you can comply with your faith-based inheritance rules. Clients will, even if they don't want to do this, they will appreciate the cultural sensitivity you're showing. So to me, it's a win-win, whatever the client decides to do. If the client feels this is important, it's a grand slam because you're showing a sensitivity and an interest in their beliefs that's admirable. And that goes back to what I said earlier from Stephen Covey, right? Seek first to understand and then to be understood. It's a wonderful way to reach out to people. So Rabbi Brody, why don't you get a little more before we get detailed, why don't you tell everybody the simplest, easiest thing they can do to go to the Ematai website, get this form, sign it, so we can start with the end result that's really easy, and then we'll go through all the detail in case people want to hear it.
Yeah, I mean the document itself, ematai.org, you'll see there a section for a halachic estate planning or estate document, and you'll be able to complete the document there. It's only a couple of things have to be filled in, and once completed, you're all set. And I want to stress the model here, Marty. I think it's very important for people to understand the model that we've created, and we're not the first to do this. I think we've done a very good job of making this user friendly is whatever you as a practitioner have set up in the what we'll call it the will or call it the plan, whatever it might be, is what is going to be enacted under American law, under civil law, and will work. We're just trying to make sure that will work not only under American law, but also work in compliance with Jewish legal requirements.
Let
And
me interrupt. Forgive me, but that's really important, and I should have said that earlier. This doesn't change anything in any of your estate planning documents. All it is an additional half a page form. You fill out a couple of blanks, get it signed. The client is now complied with Jewish law according to many, maybe most interpretations. I'll leave that phraseology to you. So you're not changing anything you would normally do. If you have a standard revocable trust plan, bam, you use it. If you have a sophisticated plan, you use it, no change. You're adding a piece of paper.
Yeah, that's exactly the point. And in fact, this piece of paper is being really being created to never be used. And so it's never to be used even in with under certainly under American laws we'll discuss. And really it's never meant to be implemented, never be really necessary to utilize in a Jewish legal court within the Jewish community because the whole point is just to make sure that you have a workaround that works within Jewish law, but allows the American civil legal process as you've established as a practitioner, the setup that you have to work itself without any conflict with the religious law.
So do you want to explain the biblical mandate? You think we should move on to that?
Sure, sure. We can.
Because that's kind of the foundation. But again, let me repeat for practitioners, do not get overwhelmed. Client says they're Jewish. You can go to the ematai.org website, and there's other organizations that have forms and documents as well. I think Ematai has done a phenomenal job making it really a great interface, user-friendly, et cetera, and practical. And you can get a simple one-page document, less than a page, fill in a few things that are not complicated. The instructions are there and print it, have the client sign it, put it in your file, give a copy to the client, and nothing else in your plan changes. But you can now tell the client that according to, is it fair to say most authorities, you've now complied with Jewish law?
I think a large, vast majority of authorities would say you've complied with Jewish law.
Yeah. There's always different opinions, but that's true for everything.
There's
Um,
always someone. There's always someone. Yeah.
so can you explain the foundation? Where does this come from? How does it come about? What is the Bible, the Torah, the Old Testament provide for?
Well, I think the basic idea of our document is to create a incentive and a legal obligation under Jewish law alone, which will make sure that everyone agrees to the fact that we're going to follow the civil estate, the plan that's been created by you, the practitioner, and not object to it under Jewish law. In other words, Jewish law is not here a mechanism that can be utilized to challenge the estate plan. And the way that this is done is to say the following. We gave a default earlier of just sort of saying you've got two sons and two daughters. Under biblical law, the entire state will basically go to sons with a limited amount that's sort of distributed to daughters for their basic welfare. And let's assume you want to distribute this equally amongst the family. Let's say we're talking about a $4 million estate. And so you say, okay, $1 million for everyone. That's sort of how you set up the system. And whatever way you want to do it, trust, whatever it might be. And so someone, would say, okay, well, under biblical law, really the sons are losing out, so to speak. Now, any good son should say, no, no, under the general wishes of following and respecting my parents, of fulfilling the general desires and requests of the deceased. Of course, I should respect their wishes anyway. But this is another mechanism under law that gives people a real incentive, which says as follows. If the estate is worth, let's say, call it $4 million, and you create an obligation, what we call in Hebrew a chov, right, which says that before I die, the moment before I die, this is how it's being set up under Jewish law, I am creating an obligation to those that would not inherit under biblical law, let's say in this case, the two daughters, which says that will be, let's say, a double amount of the estate. So we'll call it an $8 million obligation. It doesn't have to be an exact number here, and you'll see why momentarily. And it says that, listen, if my sons don't want to follow the estate plan, they still have to fulfill beforehand under Jewish law the requirements of this obligation to my daughters, which means that they will, under Jewish law, they would inherit all $4 million together, but they now have an $8 million obligation to pay to the daughters. And that's an obvious incentive for everyone to say, okay, well, I just want to follow the estate plan, which is exactly what we write in the document itself. And then everyone gets the money as distributed under the estate plan. In other words, the concept is to say we're just creating only under the Jewish legal framework, not meant to use any other manner. Under only a Jewish legal framework, a special obligation which never kicks in as long as no one challenged this document under Jewish law in a Jewish legal court. And this way, if people might challenge a state will because of other issues based on American law, but there's no then manner in which people can say, oh, we are violating a biblical law. That's why we have to challenge this state. No, we're following Jewish law through this mechanism.
So let me make a couple of comments seeking to explain, and you can correct me or expand on what I'm saying. So if you have a client that's Jewish, they may say, I don't really care about any of this. I'm not religious. It doesn't matter. But you've offered it to them. You will have, if you have a client that is Jewish, they may say, I'm not really worried about that, but okay, if it's that easy to comply with Jewish law, I'd rather be respectful of Jewish law. I'm trying to pass on not just wealth to my children, but I'm trying to create a legacy of Jewish values for my children, common amongst clients of every faith and every culture. Everyone likes to pass on, almost everyone likes to pass on something positive about their culture, their faith, their background. So here's a way that you're actually helping a client demonstrate to their children that their religious heritage, culture, and faith is important to them, even if they're not in the least bit concerned about anyone taking any action under this. For clients that are more religious, one of the concerns, at least theoretically, could be, and it should be addressed, if the clients are very religious, one of the children might say, the eldest son, for example, oh my, I understand what was done here, dividing everything equally, but under Jewish law, I'm entitled to two-thirds of the estate in the hypothetical that Rabbi Brody used, right? If there's an estate with two sons, two daughters, the oldest son gets a double portion, and the second son gets half portion. So it's two-thirds, one-third. And that's not actually correct because the daughters are mandated to get funds for care. They're mandated to get a dowry so that they're provided for marriage. And by the way, if all of this sounds arcane or inappropriate, keep in mind that at the time that this was all, first earliest discussions of this, this was providing protection for women way beyond what society is as a whole provided for. And that's another whole discussion. I don't think we should get into it, but I just want to say it's not, don't look at this in a negative way. Look at it in the historical context it was. But for a religious family, what if that eldest son decides, I could get two-thirds of the estate under Jewish law. I'm only getting a quarter. I'm not happy. I'm going to go to a Jewish court called a bet din. I'm going to a Jewish court and I'm going to sue the family, the estate, because I didn't get the appropriate share. So my understanding would be for a family that is religious and aware of a Jewish court, of Jewish courts of bet din, and they would go and pursue this document that Rabbi Brody's talking about prevents that eldest son or any child seeking to overturn the plan from creating a conflict for the family, a conflict between Jewish inheritance law and secular inheritance law. You've avoided that. So the way I view this, there's really three broad categories on that continuum. Someone that just doesn't care and it doesn't matter, but hey, thanks for thinking of me. Someone that says, oh, I want to pass on my values, my Jewish faith, my Jewish culture. Here's a nice way and I'm going to make sure everyone sees a copy because now it's just another way besides whatever charitable gifts or letter of instruction and so on that I do. It's another way to pass these values on to my kids, and they may love it, even though they're not concerned from a technical perspective. From a much more religious person's perspective, this is a very important document to prevent a family member from pursuing a claim in a Jewish court, a bet din, to contradict and try to conflict with the secular estate plan. And that could be an awful mess. So if there's any potential for conflict and the family's religious, this is really important to do. So I've given you three very different perspectives on how and why and when to use this simple document that Rabbi Brody's describing.
Yeah, absolutely. I think the middle category is going to be your most common case
Yes.
where, no one in the families wants to dispute, based on Jewish law at least, what's in the estate plan. But it's a way for the testator, right, your client to say, this was important to me to make sure I dotted all the I's and crossed the T's under Jewish law as well to reflect my values that I care about this legal system. As you correctly noted, Marty, for many centuries already, people have found different ways of working within and beyond the biblical system, but we wanted to create something that makes sure that it honors the biblical law as well. There are, though, cases, as you mentioned, where people might want to try to utilize the religious law more than anything to torment the family, to make them feel like they're violating religious law. We had an interesting case recently. It was a family of, well, let's call it, five children. And I'm going to change the numbers, of course, and the details. And four of them were religiously observant. The oldest son, the oldest child, who was also a son, was not religiously observant. And there was also a lot of difficult family dynamics in the family. And at that point, the oldest son was sort of not getting the same inheritance as others, just sort of wanted to torment his siblings by saying, "Oh, I'm going to challenge this in a religious court because I feel disenfranchised." And what a terrible legacy, right, that was for the children to have to deal with, that the father had passed away. And this simple document could have prevented that type of weaponization of Jewish law to sort of terrorize the family in a really uncomfortable manner. But those cases usually don't come up. And the second category is the thing really where you're going to be able to offer as a practitioner something to make the testator feel very good about the legacy they're leaving.
In the context of the example that you gave, it would seem to me that if they had signed the form that you have on Ematai's website, and the eldest son took this to a Jewish court of Bet Din, the court would look at this document and say, it's resolved.
Absolutely. That's precisely the point. You're closing the avenue for anyone to cause that type of claim in a Jewish legal court. But I also want to stress, though, that we wrote the document in a way, and I think that this is something that we've improved upon some of the existing models out there in the Jewish community, to make it clear that this is a document that is only meant to be used for Jewish legal considerations in a Jewish legal court. We've designed this in a way, and Marty certainly had a lot of input amongst others as well, that we think that any American civil court, state court would look at this and say, no, 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 this has nothing to do with us and the estate plan. This is a Jewish ritual matter alone. And the reason why we did that is we want to assure you as a practitioner that this document isn't something which can somehow be weaponized and used against the plan that you've created for the testator. And so I think that's very important to recognize. This is something really meant to assure families you're following Jewish law, and especially if there's a conflict, even if it's not a conflict, but cannot be utilized, in our opinion at least, in a civil court in a civil dispute.
So let me just emphasize something about this. So, from the practitioner's lens, I want to repeat what you just said because it's probably the foremost question on some. Can I get in trouble or create a problem by doing this? I don't see how that can possibly happen. Rabbi Brody just told you he doesn't see how it can possibly happen. But I think there's another step. By taking this simple step and completing this document, if anybody in the family would want to assert a right, not in secular court, because that's going to be based on your documents, but in a Jewish religious court, a bet din, this document, this 2 minute process of signing a simple document deflects, prevents that challenge from going anywhere. So if you as a practitioner are serving a Jewish client where there could be family conflict, which is probably almost every estate, right? Families, you know, families can be very dysfunctional. Doesn't matter what faith they have or don't have. But for 2 minutes of effort, you can prevent this one avenue of conflict, why wouldn't you do this? It's not just only about adhering to Jewish law, it's about preserving a family so no one in the family can try to argue in Jewish court that under Jewish law something different should be done just for creating conflict. The Jewish word is lahachas, right? Just because they're angry, they want to go out and make something bad happen. 2 minutes of time, you put that to rest. And if you explain that to the client, they're going to be appreciative and grateful for what you've done.
Yeah, absolutely. It's one of those ways in which the practitioner is being culturally sensitive and saying, let me make sure you're covered for things that you care about, and to close that option, because as a practitioner you want to create the plan that's going to stand up the best, that's going to deal with the possibilities that you're anticipating might cause some form of questions down the road. And this is certainly one of those issues that could come up within the religious, particularly religious, Jewish family.
Do you have a few more minutes to talk about a couple more concepts that you mentioned? So one of the points you made in the email you sent with the topics that we were going to talk about, I think is really vital. Can you speak? And I know you've already commented a few times, as have I, but just talk about how a practitioner, whatever's, it's not only the attorney, the wealth advisor or somebody else may be involved in helping with the planning. How does the practitioner, how can they talk? How should they talk to the client about these issues?
Well, I think that in general, I'm sure that all practitioners want to get a sense of who's the client in front of me and what are the values they care about, what are the issues they really care about. And within a religious Jewish family, the Jewish legal part is super important. I mean, it is something which is reflective of values and of legacy, and in ways which you might not anticipate, but whether it comes to healthcare matters or even matters of estate planning, they might want to even consult with their rabbi to make sure that this is something that it's being done in a way that confides within Jewish law. That's something, we see that in the hospital context and medical context a lot. Suddenly, all of a sudden, doctors like, oh, this clergyman's coming in. Like, where's that coming from? And I think doctors have gotten used to that a bit, that concept. And I think that for practitioners and, for the estate planning as well, it's important for them to get used to that concept as well. Also because that you might not even realize that they're worried or thinking about this issue or talking to someone else about it. And so I think it's great to just put on the table, I know you're of the Jewish faith. I know you're a religious person. I can offer you and help you talk through also the planning to make sure that confides within Jewish law and expresses your values. Would you like that, service? What a great service. I mean, how great. Put yourself in the shoes of the client here who's thinking, wow, what a sensitive, human being and a practitioner this is, who's really trying to come and meet me and my needs as opposed to just preparing some boilerplate type of, plan.
Let me make three quick comments. First, what Rabbi Brody described, you don't have to be an expert on Jewish law. You don't have to be Jewish. If you want to help a client who is Jewish, in effect, using these materials and these resources, you can punt. Another in part B of the first of the three I was going to make, you're punting. I do this on every faith-based estate plan, and I do lots of them. I can tell you, I've spent a lot of time with Rabbi Brody and since the early 90s writing and lecturing and researching on the very topics we're talking about. And I've done this in great detail for decades. When a client of any faith comes to me, I always defer to their religious advisor. I can say, listen, I'll tell you what I believe or what I know, but you need to consult with your rabbi, imam, religious priest, pastor, whatever. I don't want to be held as the expert because even with whatever knowledge I have, I can't know what particular perspectives their rabbi in this case or religious advisor more broadly is going to take. So for any faith-based plan, I always punt. And I've spent a tremendous amount of time doing this work for decades. I punt. You should punt too. Here's a document from Ematai. Here's what it seems to solve for you. Here's one document that addresses healthcare decision. Here's another that addresses inheritance, or the Jewish word Yerusha. Talk to your rabbi. Talk to your advisor. So you don't have to ever feel you're getting a beyond your skis giving advice on something you don't know. It's an easy punt. And their religious advisor, their rabbi, in the case of the context of this program, will advise them. So you don't have to worry. Second, I'm sorry to do this, but I'm doing this on probably every webinar I do on any topic. Think of what AI is doing to planning. AI is dramatically changing the role of estate planning attorneys and other estate planning advisors. In fact, it's going to propel more involvement by wealth advisors into estate planning. The topic we're talking about today, the human aspects, religious aspects, whatever personal aspects of planning that a client may have, the human aspects of all of this and the emotional aspects, and we've Rabbi Brody, with some of the examples he's given, is illustrated that this is one thing AI is not going to be able to do for a very long time, if ever. We need to both use creativity, but to focus on human aspects of planning. So this is something to continue to empower you. And just a final point more broadly, because I've made these comments throughout because I think it's important. There's an organization called Tannenbaum, which is a secular organization that has incredible resources on maybe 10, 12 different faiths in end of life and medical decision making. So if you have other clients in other faiths and you want more resources, take a look at their website. Um, do I need to have this document, this Shtar Chov? Do I need to have it witnessed, notarized? Just maybe speak quickly to the formalities. Do I need a lawyer
No,
to do it?
now it doesn't have to be witnessed and it doesn't have to be notarized. It's following a Jewish legal mechanism, but it doesn't require that to be done, which is another reason, by the way, we don't think it would actually hold up if someone ever tried to produce this in American civil court. It's following just sort of Jewish legal mechanisms of creating this type of obligation, which is not meant to be utilized. And to be honest, I don't know if a state attorney actually has to be involved in this. And, might have a situation where you say, listen, I know Jewish law matters to you, Jewish values matter to you. And as a practitioner, I'm prepared now under American civil law, but I want you to know about this. And here's the document, and you can bring it to your rabbi, and you and your rabbi can, decide if this works for you. So you can punt that way also, if you want to. But I also think that we've created a way that'll make it understandable for you, whether you're Jewish or not Jewish, by just understanding what we're doing on this document. And of course, you can complete it with your client as well.
And by the way, not to ruffle the feathers of any lawyers listening, what Rabbi Brody just suggested, this is another tool in the financial or wealth advisor's toolkit. You may meet quarterly with a client over years and years of time. The client may go once every 5 or 10 years to an estate planning attorney. The attorney doesn't have the length of experience and necessarily the depth of relationship that you do. If you are aware that the client is of the Jewish faith, you can ask them, did your attorney prepare documents to address Jewish law? If not, we can help you do that. And you can use the Ematai website for the forms. I will say emphatically, I'm not a fan of a wealth advisor who is not an attorney and has limited background helping a client complete a trust document, for example. And I don't think very many would, which is prudent. But here is something you can complete the documents, because these are, while they're legal documents, they're Jewish legal documents. They're not American legal documents. Is that a fair statement?
Yeah, absolutely. I mean, certainly when it comes to the estate document here, what we call the shtar, that is meant to be just for Jewish, legal purposes. When it comes to the healthcare document,
Right.
that of course is a document which is meant to be usable in American hospitals and under American law, and that of course is, has a different nature to it. But this
Thank you.
estate,
Thank you. That's an important distinction that I didn't make.
Yeah, but the estate one is really just a matter of fulfilling one's religious obligations or really religious, legal fidelity without impacting the civil plan, that estate plan that you've prepared.
Do you have any other thoughts or comments that you want to make about Jewish inheritance that we should share before we wrap up?
Just the one last thing I'll mention is that sometimes, people might say, "Oh, is this like mean if you suggest this? Like, does this mean I'm not following Jewish law? Like, am I, not following the biblical mandate here?" And I think that's important just to understand that Jewish religious law over many centuries has used a whole range of different documents and mechanisms in order to make sure that people can distribute their estate within their wishes. The biblical law became like a default, but anyone who's planning over the centuries was following different mechanisms in order to complete their wishes. And so when you're doing this, is just sort of the 2026 version of how to do this in the United States.
One last thing, and I should have brought it up earlier, and forgive me that I didn't. You have, and I can't remember the phrase or term you used for it, but you have, I'll call it a questionnaire that's almost like a guide that someone can fill out to start to assess for healthcare decisions, how they feel and what they want to do. Can you just talk to that for a minute? It's not our topic today, but in the context of planning for Jewish clients, it could be very useful. And I'm not sure I've seen anything like it anywhere else.
Yeah, so our healthcare directive model is less of a directive and much more of a power of attorney. It's clarifying who should make the decisions for you. If a rabbi needs to be consulted, which rabbi should be consulted, and telling the healthcare providers you care about Jewish law and custom. But, as you know, any power of attorney, a proxy who has that healthcare role, should be asking the person who's appointing them, well, what would you want? Like, what is it that you care about? And they've told you, I care about Jewish law and custom. But within Jewish law and custom, there's a whole range of different types of perspectives. And the conversation starter is meant to create a non-legal type of document, which is meant to help families engage with each other and just have a sense of, okay, we're going to use the method, what we call substituted judgment. We're trying to make the best decisions we can on your behalf. Give us a sense of what you care about. And to be honest, Marty, we found for this, for this conversation guide, Jews and non-Jews alike are very much into this conversation model. It's sensitive to the religious person, but it doesn't have to be a religious person who utilizes this conversation guide in order to just share with their loved ones how they think about some questions of decision making and risk taking and pain tolerance. In fact, we just had an event in Harrisburg, Pennsylvania. We did a workshop. We were presenting this, and a number of doctors and lawyers in the area who weren't Jewish were on the panel, sort of explaining how these things work in the legal realm and in the medical realm. They're like, wow, I could use this for anyone, right? And I could use this for myself, right? You don't have to be Jewish per se to benefit from this conversation starter. And we hope that'll be a real model that others can utilize as well.
I want to echo and emphasize what Rabbi Brody just said. Is the phrase, is it called conversation guide or conversation starter?
Conversation guide, yeah.
The conversation guide that they have is really a valuable tool for any practitioner because what it does is help give questions that a client should think about in order to communicate how they feel to their loved ones. It can be very, very valuable, regardless of where on the spectrum or whether, as Rabbi Brody said, they're Jewish or not. A very valuable tool. Um, last last quick point, just so we're complete, even though we're not digging into it in any detail. Do you have materials on organ donations that would be helpful to practitioners?
Absolutely. We have an initiative called Option 18, once again on our website, ematai.org, and which explains perspectives on organ donation within Jewish law. And, those cases don't come up every day, those organ donation cases. Unfortunately or fortunately, vast majority of people don't die in a way in which they can donate organs. But many, many people care very much about if they die in a manner in which organ donation is possible, They would love to give the life gift of life to someone else, and we want to help make sure that's done in a way that's both legally sensitive within American law, but also sensitive within ritual law as well. And all that's on our website as well.
My 6-year-old grandson needs a kidney transplant because of a genetic issue he has. And I can tell everybody watching, when you have a loved one that is going to need an organ donation to survive, the importance of encouraging others to consider donating organs is just monumental. It's really important. So do give some thought to it. It's not our topic today. We could easily do a whole hour on just organ donations because there's lots of issues under Jewish law, but there are materials there. When you have Jewish clients, please encourage them to go look and consider it. I can tell you personally that it's very important. And for all clients, it's something that I think we all as estate planners need to bring up more often. I'm going to give you the last word and then ask you to summarize, if you have no last words, what we've done, and then we'll wrap up.
I think just the key takeaway point here is that you as a practitioner really can offer tools, whether you're Jewish or not Jewish, that are easy for you to understand and for your clients to understand as well. They'll make them feel like they are following, they not just feel like it, but they generally are following the values that they care about and passing those on to their loved ones. What a great gift as a practitioner to give to your clients.
I'd like to thank Rabbi Brody. I did not know until this moment, maybe I forgot, but I don't think I knew that you had a PhD in law. That's amazing. Thank you everyone for joining. This was really to be educational, not an advertisement for Ematai. We kept referring to Ematai because the resources are very easy to use, they're very valuable, and they can make anybody who has no interest, background, or time to devote to this empower you to help clients where this is important. And we've tried to stress the practical implications to wherever clients are on the religious spectrum, why this can be important. And I think it's a great approach to help you give more value and more meaning to your clients in the estate planning process. So thank you for joining me, and thank you again, Rabbi Brody.